Well, so talk to us a little bit more about the taxation of trust.
So depending on what kind of trust that you have, there's going to be different tax implications to those. So if you have, let's say, an irrevocable trust, then the trust is going to have a separate tax ID number, and what is inside that trust is actually going to be taxed to the trust, and the trust itself is going to have to file an income tax return. Generally, if it's a revocable trust, then the trust itself is not going to pay income tax, and the income tax on whatever the assets make inside the trust are just going to be treated on the individual grantor's tax return. So it'll be on their 1040, not on a tax return for the trust. Often when you're giving money to a trust, an irrevocable trust, there may be gift tax issues that arise with that. So typically what you'll see is if you're gifting money to an irrevocable trust, there will be gift tax consequences as long as if you get over that $14,000 a year annual exclusion amount. Gifts to revocable trusts, because they are revocable, there's really no gift tax consequence to that. As far as estate taxes are concerned, remember, estate taxes are something that's paid at your death. Well, an irrevocable trust, those are created generally during your lifetime, and the transfers are made during your lifetime. So the taxes have been taken care of through the gift tax process. So generally there's no estate taxes due on an irrevocable trust, unless for some reason that irrevocable trust is defective. But for revocable trusts, because they are revocable, that whatever's in that trust is included in your estate for estate tax purposes. So revocable trusts are not going to get you out from under estate taxes. For generation skipping transfer tax, revocable trusts are, again, just like gift taxes. There's not going to be any GST taxes on revocable trusts. For irrevocable trust, you might have GST taxes just like you might have gift taxes, depending on who the beneficiaries are of the trust and how much you gave to the trust in a given year. In your book, there's actually on page 315, there's a really good chart that kind of breaks down the taxation of trusts, and so I would look carefully at that.
Great. Okay, so you've mentioned revocable and irrevocable trust, but so tell me a little bit more about that in terms of like when they're created, that sort of thing.
Okay, so there's basically two main types of trusts, which are the revocable trust and the irrevocable trust. And so just like you would expect from their name, a revocable trust can be changed, it can be amended, or it can be terminated, revoked. So an irrevocable trust, once you set it up, in general, it cannot be revoked. It can only terminate by its terms, and it usually cannot be amended or modified.
Okay.
And so that's kind of the main difference between revocable and irrevocable trusts.
Okay. And then we've got inter vivos, which is during life, and then testamentary, which is at death, obviously.
Yeah, and so those terms really refer not necessarily to types of trust, but really like when trusts are created.
All right.
So with the inter vivos trust, you're making that during your lifetime. Testamentary trusts are trusts that you're making that come into being after your death.
Okay.
So a lot of times, what you'll see in a client's estate planning documents is in their will, let's say, there might be a trust for their children, but that children doesn't spring into being until that person dies.
Right.
And then the trust comes into being.
The old bypass trust for the husband and wife type thing.
Right, yeah.
Right.
That's typically a testamentary trust as well.
What other classes of trust?
So there's a couple of different ones. One that we've talked about before is kind of the contingent trust that we talked about in the context of wills. And what you'll see there is it's kind of a trust that's in waiting that may or may not ever be used. And so if there's a beneficiary who happens to need that particular trust, then that trust will come into being just for that particular need. And otherwise, it just kind of lays dormant and may never be used. Typically, we'll see there's a lot of trusts that are called grantor trusts. And so what a grantor trust is, and those are generally some form of, they could be an irrevocable trust, or a revocable trust can be a grantor trust, but it's usually a trust that is an inter vivos trust that's made while you're living. And so what happens with a grantor trust is whatever income or appreciation that the trust makes, that those things still get taxed as income to the person who makes the trust, the grantor. So that's what a grantor trust does. When we talk about pour over, what we're talking about is something that pours over from one to another. So you can have what's called a pour over will, or you can have a pour over trust, and what that means is that anything that gets passed through that instrument gets poured over into another existing trust. And so we see that a lot of times in revocable living trust planning. We'll see pour over instruments there. The key thing with the trust is whether or not they're funded. Right. And so that's always the big issue with trusts. And so what we're talking about is you can have a trust document that's written that can be unfunded because no assets actually get passed over into the trust. And so what you're looking for when you do trusts is you want to make sure for your client's benefit that if it's supposed to be funded, that it is funded. If there's supposed to be assets in the trust, make sure that those assets get in the trust and help them and their attorney do that.
Right. Which brings another question to me. What is a living trust? And you'll understand why I'm getting into that in a little bit.
Yep. So a living trust is a inter vivos trust. So it's a trust that you make during your lifetime, and it is a revocable trust. So it can be changed or amended or terminated during your lifetime. So that's what a living trust is.
Well, and the only reason I ask that is because I've got clients a lot of times that come into my office and they say, oh, I have a living trust, so my probate is taken care of. My first question to them is always the same, which is who drew it up? Because there are literally living trust salesmen out there that, the only thing I'm going to say is if I know that it was a living trust salesman that drew it up, I'm going to get them to have it reviewed by an estate attorney.
Yeah, living trusts are kind of this area that went through a huge period of abuse, particularly in Texas. And so what basically happened in really the 80s was kind of the heyday, and it lasted into the 90s, and we still see it some today, is unlicensed non-attorneys would go and have estate planning seminars, and they would sell these living trust kits. And so they would do these seminars, they would sign people up to do living trusts, and they would sell them these living trust kits. Now there were several problems with them. One, for the most part, they were not particularly well drafted. So we have reviewed over the years many living trusts that pages were missing, where it referred to paragraphs that didn't exist, that the cross references didn't work, that it was just a mess and it wasn't well drafted. And most of that was because the salesperson didn't know anything really about living trusts except whatever was in their presentation.
Right.
And so they couldn't even help. And since it wasn't drafted by an attorney but just by a word processor, they were real problematic. The second is that a lot of those things were sold on a very hard sell basis. And so there were a lot of people that were really hard selling their clients. also, some of them were really, really expensive. So I had a client not too many years ago that brought me the living trust that they had bought from a living trust salesman. And I knew it was going to be a problem the second it walked in the door, because she had told me she had bought it from a salesperson. And she came in, and the binder is literally the nicest binder I have ever seen in my life. It's this beautiful leather portfolio. It had their client's name on it on both the side and on the front in gold foil, and it was embossed. And I mean, it was a terrific looking binder. Now everything inside it was total crap, but it was a really nice looking binder. The thing that was shocking to me, though, is that they had paid $20,000 for this.
Ouch.
And I don't know about you, but $20,000 is really a lot of money to pay for essentially a folder. The problem with that kind of period of Texas estate planning history is that it kind of put a black eye on the living trust
Right.
as an instrument. And so what ended up happening was we kind of threw the baby out with the bathwater for about a good 20-year time period. The attorney community reacted to the living trust salesman by saying, basically, you don't ever, there's never a purpose for using a living trust. And the truth is that the living trust does have some advantages over some other estate planning options, and it should be considered as one of the options. It shouldn't just be thrown out just because of the abuses of
Right.
kind of a group of bad apples. So what we're starting to see in the industry is a kind of a return to the living trust as a viable estate plan, and it's I would say for most of our clients it's kind of the preferred option if they can afford to do it.
Great. Well, and we've talked about how they avoid probate and all those other things. Talk to us just a little bit, sort of go through and give us some highlights of some different trusts that you draw up regularly.
Well, let's start by kind of turning again to the living trust. So that's
Okay.
probably the main one that you're going to see walk into your office, and it's the main one that we end up drawing up. So kind of the pros to the living trust when you look at it is if it's funded properly, the trust is going to completely avoid probate. So that by far and away is the positive. Because it avoids probate, and probate is a public process, it's a public record,
Right.
then the trust is going to pass privately. Well, the nice thing about passing privately is that because it passes privately, it discourages will contests and creditor claims, because beneficiaries or potential beneficiaries who were written out of the trust and are no longer beneficiaries, they don't necessarily have to be informed that the trust assets are passing to someone else. And so and there's no public filing, so they don't really have anywhere to go down and look at what the trust says. They don't have any right to do that. And so that's a positive. The same thing is true also of creditor claims. Often creditors, their only claim is against the estate. Well, they don't actually have a claim against the trust, because remember, the trust is a separate legal entity. So when things pass from the trust to the ultimate beneficiary, it doesn't go through probate, which is essentially also a creditor claims process. The other pro is, just like in wills, you can do some positive things from an estate tax planning standpoint. Living trusts benefit from the step up in basis in the same way that wills do. And you can do the same sort of estate tax planning inside a revocable trust that you can do inside of a will. So they kind of retain those same advantages. The big con of living trusts is we often find that they are not funded. that assets have not been retitled or transferred into the name of the living trust. And so, just like the lady that had the really nice $20,000 binder where the documents were not very good, even though the documents weren't very good, the biggest problem was that there actually was no retitling of assets into the trust. And so what does that look like? So her house was still in her personal name. It should have been deeded over to the trust. Her bank accounts were still in her personal name. They should have been deeded over to the trust. Her investment accounts were still in her personal name. They should have been deeded over to the trust. Her retirement accounts still had beneficiary designations on them, when probably what should have happened was some of those beneficiary designations should have been the trust. Her car was still in her name. It should have been in the name of the trust on the certificate of title. And so that sort of follow along work is probably the biggest problem with living trust. It's also the biggest opportunity from a financial planner's perspective. Because remember, you're having this annual review with clients. So when they come to you and they say that they have done the living trust, then the next question should be, okay, what has been retitled into the name of the trust? And so you can really help them through their annual review to list, when they list what bank accounts they have on your little questionnaire that you do with them, have them list whose name is on the bank account statement besides whose name is on the beneficiary. So if you notice that it's all in their personal name, then the next question you need to ask is, well, shouldn't all this be in the name of your living trust? And they better answer yes. And then you better work with them and with their attorney to make sure that that stuff actually gets put in there. If you notice that their house is still in their name, then you need to go and help them find an attorney who can do a deed and put that into the name of the trust. So there's a real opportunity with living trust to be helpful, again, to your clients in this annual review process.